out of the previous discussion. We had a very detailed and informative presentation from Professor Kusuda on the massive growth of immigration detention, which of course is nominally a civil form of custody. And as she noted, one of the major factors contributing to that explosive growth in detention has been the expansion of enforcement policies and practices that subject ever larger categories of individuals to removal charges and then custody, essentially without the individualized bond hearings to which individuals normally would be entitled, and then subsequently without the opportunity to seek any discretionary individualized relief from removal, which again, many people are entitled to. So in other words, detention has been deemed mandatory for many individuals, most notably individuals alleged to be removable on criminal grounds, which of course now have come to include a sweeping array of offenses, both serious and minor. And for those individuals, individualized discretion by individual immigration judges has been curtailed. They must be taken into custody and then not released from custody. And I think it is relevant to note that the language of the statute speaks in terms of custody and not detention in that provision. And then when it comes to their deportability itself, the ability to get for those individuals to get discretionary relief has also been curtailed. So what that means is that all of the principles discussed in the second panel, and Julie Myerswood made this point, all of those have been deemed essentially beside the point for these categories of individuals, whether it be the international legal standards discussed by Lindsay Jenkins, or the principles discussed by Lisa Simpson in terms of universal screening and making sure to use a validated risk assessment tool. The room for applying those principles is limited, and not necessarily eliminated, but certainly limited. And those legal provisions themselves have raised serious constitutional problems, but to a considerable extent, the government has interpreted, in the room that it's had to interpret those statutes, has interpreted them rather broadly, and that's been true in, it seems, every administration since the laws have come into place in the 1990s. And then that's put the federal courts in the position of having to push back and then restore some individualized assessments on the margins, but really on the margins. Now, those discussions have taken place largely as a matter of due process. On the criminal justice side, we have had this parallel discussion about mandatory minimum sentences, which have been adopted by legislatures to constrain the discretion of sentencing judges when imposing sentences without regard to the traditional individualized sentencing factors concerning the nature and circumstances of the offender, the characteristics of the defendant, and other relevant sentencing factors. The legal discussion in that context has tended to be less about due process and more about proportionality under the Eighth Amendment, and whether sentences that don't involve individualized consideration of those factors are constitutionally disproportionate. Those legal challenges haven't tended to be very successful because the Supreme Court has given quite a bit of latitude to legislative determinations about sentencing. But in recent years, there's been quite a bit of legislative activity, including here in Louisiana, as states have undertaken to temper the scale and severity of criminal incarceration. And interestingly, even Justice Kennedy, who is inclined in his jurisprudence to give a lot of latitude, has also spoken out about the severity of some of these sentences. Those efforts have involved some silos, and one of the interesting things that we can hope for in this discussion is that we can break down some of those silos and see if there are interesting lessons to learn in both directions. So first we'll hear from Representative Joseph Lopinto, who has been a member of the Louisiana House of Representatives since 2007, representing the 80th District, which covers Metairie and other parts of Jefferson Parish. He's served on the Criminal Justice Administration Committee and the Homeland Security Committee. He's a graduate of this university and this law school, so this is sort of a homecoming for him. And he's been a real leader in pushing sentencing reform and other kinds of criminal justice reforms, which I'm very excited to hear more about. We also have to talk on the immigration side, Michael Tan, who's a staff attorney at the ACLU Immigrants' Rights Project. He's a graduate of Harvard College and Yale Law School, where he worked on workers' rights and immigrants' rights in the clinical programs. He clerked for Judge McEwen, Margaret McEwen, of the U.S. Court of Appeals for the Ninth Circuit, and has actively litigated many of the leading questions arising from mandatory immigration detention. So,
obviously, I'd like to give a little bit of background from my area. For the people that aren't here from Louisiana, welcome. glad y'all are here. But on the other standpoint, I want to introduce you, since you're here in Louisiana, we've recently been named the safest community in America. Now, nobody heard that, right? Because it's not true. But we incarcerate 40,000 inmates and have the highest incarceration rate in the entire world. So why isn't it working? Because it doesn't work. We can't incarcerate ourselves out of this problem. And that coming from me, who was a policeman for 8 years. I worked as a police officer for 8 years while I went to law school here at night. Put many people in jail. In fact, actually put a recommendation in for pardon the first time for a person that I put in jail. That just actually happened for me. That was the first for me. But got me involved. When I got elected back in 2007 and started this process, if you go look at my old campaign literature, it said nothing about, okay, let's try to do some smart on crime legislation. That wasn't the case. It wasn't until I got to Baton Rouge and realized, you know what, some things have to change. We rely way too much on mandatory minimums in the state of Louisiana and rest of the country. And a lot of that came from the 80s, 80s and 90s when we put in different legislation in order to basically try to make this happen. Well, those times have changed, and we can prove through facts that they are there. Now, I was named on the Louisiana Sentencing Commission several years ago, and there's been a huge effort through the Vera Institute and the Pew Foundation in order to make some changes here in Louisiana. And that has been a significant factor in the changes that we have made. And what we've done is just try to increase parole eligibility, try to increase the ability to have good time. I'm the first person to say we have some bad people on the streets of Louisiana that need to go to jail. That aren't to the point where rehabilitation, not rehabilitation, but counseling at their age are going to make that happen. But I'm also the same person to say that 20-year-old is not the same when he's 40 years old. That 20-year-old is not the same when he's 60 years old. And we throw away life sentences like it's nothing around here. We'll have a 3 strikes you're out, and okay, you broke into someone's house on your 3rd strike and you had 2 previous worthless checks. Okay, you're going to jail for life now. And don't get me wrong, the person may need to go spend some jail time in order to get right, or I hate to say this, but incarcerate that person out of his teenage and younger adolescent years in order to do so. But the problem is our system doesn't even allow anybody to change anymore. We've thrown away the key. We've put that person in jail for life. Out of the 40,000 incarcerated inmates, we have over 5,000 lifers here in the state of Louisiana that will never. Not included in those 5,000 lifers are people that have sentences that may be 60, 70 years old, which ultimately they'll never get out also, because they won't outlive the amount of time that they have in prison. So it's trying to get the legislature together to say, what is smart? What is the right way to do this? And we've been helped by numerous cases. I'll say, and I hate to put it on my leadership, but because of my background, you have people that are in similar districts to me. I'm from the whitest, most conservative district right in the middle of Metairie. That if you went and asked my constituents, it's not a hard vote for me to put somebody in jail. It's not going to get me unelected for me to do that. Now, that's not the case with every representative that's out there. But it's not a hard vote for me politically to put somebody in jail. But what happens is somebody like myself to know the big picture and to get the big picture and bring that forward allows other people that are in the same opportunity, maybe same type of districts, to go, you know what, I don't know everything. I may be an expert on insurance, or I may be an expert on education, but I know Joe Lopinto is an expert on criminal justice. And if he goes to the microphone and says, yes, this is going to let some people out, but this is the right type of people we need to let out, I'm going to trust him on that, and I'm going to vote with him on that green vote today. And it's about having that respect to the other colleagues to know that. And the same reason, my background obviously is a criminal justice expert. Well, that insurance expert, I don't know everything about it, but I rely on my colleagues that serve on those committees to go to them and say, don't vote up or down. Because truthfully, I can read the bill, but I don't know what the long-term effects are. So we have to have trust in those colleagues, and it's about getting the right person to bring these bills forward that have those trusts in order to make them pass. And truthfully, we've had great success here in Louisiana. I mean, the bills that we are passing over the last 2 or 3 years have not passed with small majorities in the legislature. They're passing overwhelmingly. So I look forward to some good things going forward. There's been hesitancy to touch anything that's dealing with any violent crimes, which I think is a way that we still need to go if we're going to affect a lot of change here. And part of that is getting the administration on board with the legislature. I don't think the legislative branch is really holding that train back. It's our executive branch that's doing it right now. Am I? Well, I mean, I'm done, or I talk later.
Okay, well, we can come back and
give a politician a microphone. I won't shut up.
You're better than a lot of professors I have. So, Michael, go ahead.
Great. Good afternoon, everyone. I want to start by thanking Ruthie and Human Rights First for hosting today's event and inviting me to participate, and thank all of you, of course, for joining in the conversation. As Anil mentioned, I'm primarily going to be speaking about mandatory immigration detention, specifically the mandatory detention of immigrants whom the government is seeking to deport based on their criminal offenses. But I'm also going to touch very briefly at the end on what might be a better analog to mandatory sentencing laws in the immigration system, namely mandatory deportation. And what I'm referring to, as many of you will know, are the so-called aggravated felony grounds of the immigration statutes that guarantee the deportation of many immigrants, including green card holders, who are convicted of a wide swath of crimes. So Anil already provided a basic overview of the mandatory detention statute, but I know since we have a mixed audience, I just want to talk a little bit more concretely about what it entails. So you're put in mandatory detention if the government is charging you with deportation or removal based on your criminal offenses. And you're put in detention at the outset of your case. And under the government's interpretation of the statute, you stay locked up through the immigration court proceedings and then up on the administrative appeal to the Board of Immigration Appeals, which is the administrative appellate tribunal. And what that means is for the whole course of your case, you never get a chance to go before a judge and argue that you don't need to be locked up because you pose no flight risk or danger to the community that requires your detention. You're not eligible for release on bond or release on your own recognizance. And in fact, you never get any kind of individualized review as to whether you yourself are a flight risk or danger. All ICE does at the beginning is determine, hey, you have a charge that triggers the mandatory detention statute, so you're in mandatory lockup for as long as it takes to finish your case. So obviously, that rule, that detention system, raises an array of very serious civil liberties concerns. As many of you know, in 2003, the Supreme Court upheld the constitutionality of mandatory immigration detention in a case called Damore against Kim. The ACLU litigated that case. Anil worked on that case. That said, notwithstanding Damore, I think we can all recognize that mandatory detention is a very severe deprivation of liberty and raises civil liberties concerns, as well as human rights concerns. But I actually wanted to focus more today on the core policy question, namely, is mandatory detention a good way to run a detention system? And I think this was made clear in the previous panel. Plainly, no, it's a terrible way to run a detention system. When you think about it, what mandatory detention does is strip both the custodian, here ICE, and the immigration courts of their discretion over custody determinations. So it takes away ICE's authority to decide on the front end whether someone needs to be locked up, and then strips immigration judges of the power to make that decision at a bond hearing. So put another way, and Anil adverted to this, mandatory detention is premised on sort of an a priori decision to treat these very broad groups of people as categorical flight risks. So it's set up to be over-inclusive. You get a lot of false positives. ICE is required to lock up people who it doesn't need to lock up because they could, for example, be effectively supervised under the programs we were talking about this morning. So I think any criminal justice person, any sort of person who just sort of stops and thinks about it would tell you that this is a terrible waste of detention resources, because detention beds should be reserved for people who will actually try to run away from the authorities. And this is kind of a more technical point, but This was flagged in the earlier panel as well. I think mandatory detention is also sort of conceptually problematic because it treats flight risk as this static, unchanging thing. But as we know from the research, your risk of flight, your risk profile changes over time. So, some of the speakers this morning talked about how, at the beginning of your case, when you're in immigration court, say you have a lawyer, say you're applying for asylum, there might not be any need to lock you up because you have every incentive to show up for court and fight for your right to stay in the country and be here legally. I mean, that's what you want to do, so you're going to show up. But your risk profile might change once the immigration judge or the board issues a removal order. You may or may not need to be detained at that point. Who knows? It's sort of an individualized thing. But under mandatory detention, you're locked up at the beginning and you're just locked up throughout the course of the case. There's no attention to the risk any given person poses. So just to give you a bit of the history, how did we end up here? How did we get the mandatory detention regime? Before 1998, the power to detain immigrants pending deportation proceedings was discretionary and permitted release on bond. Congress enacts the first mandatory immigration detention statute in 1988, requiring the detention of people convicted of so-called aggravated felonies, which at the time was sort of narrowly defined to include murder, drug trafficking, and certain kinds of weapons trafficking. That aggravated felony definition is expanded in '94, so relatedly, the number of people in mandatory lockup is expanded. But of course, it's the 1996 immigration reform that really brings the drastic changes, enacting our current law, which requires the detention of virtually all immigrants who are facing removal for their past offenses. Now, why did this happen? The best account that I know of, and there are many, is Margaret Taylor's article. Margaret Taylor's a law professor, I think at Wake Forest, thank you. She has an article on Demore against Kim in a volume called Immigration Law Stories, published in 2005, I think it's by West. It has a really great title, this article, Demore against Kim, Judicial Deference to Congressional Folly. Tell us what you really think, Professor Taylor. So, by Congress to this undeniable fact that Julie Myers-Wood spoke about this morning. The Immigration Service, or INS, wasn't deporting most immigrants convicted of deportable offenses, and the statistics were especially bad for people who weren't detained. We saw the numbers in the prior panel. I have other numbers. There's an OIG, or an Inspector General report from '96 that says INS was deporting only 11% of non-detained immigrants who had final deportation orders. And so I think a prevailing view emerged that we live with today, right? That mass detention, and moreover mandatory detention, is a linchpin of effective immigration enforcement. But that position ignores the very complex reasons why INS wasn't deporting non-citizens who had deportable criminal offenses. Until fairly recently, the agency had no capacity really to identify and apprehend immigrant offenders, to keep tabs on people placed in deportation proceedings, and to enforce removal orders. In many cases, INS didn't even try to enforce deportation orders against people who were not detained. The same study showed, for example, that almost 40% of the time, the INS didn't even bother asking people to show up for their deportation. They didn't order a deportation notice. And even when a surrender notice was issued, people just didn't show up. Another big factor was is the microphone giving you interference?
A little static.
I'm getting overly excited, I'm sorry. I'll calm down, I'll have some water. So another factor here was INS's very limited detention capacity at the time. So in the early 80s, for example, the INS had about 2,200 detention beds. And most of the facilities were used sort of for short-term custody for people caught and turned around at the southern border. There were very few beds for people in deportation proceedings in the interior. And so this led the agency to routinely release people who they thought were a flight risk because they just didn't have the beds for them. And that further contributed to the very low rates of removal. All of this is to say, the problem wasn't that INS officials or immigration judges were being softies and too lenient, or that they were making bad calls on custody decisions, such that you had to take that authority away from them and make detention mandatory. The problem was a lack of bed space and the absence of systems to keep track of people who were at liberty during their deportation proceedings and at liberty when a final order was entered against them. I think it's also worth emphasizing, and this has become forgotten, I think, even in the very recent history or recent memory of these debates, many people on INS opposed mandatory detention at the time it was enacted. Thank you. So many people in INS were against mandatory detention. Its implementation ended up being delayed 2 years under a provision of the statute because the agency didn't have enough beds to fulfill the new detention mandates. And notably, 4 top INS officials filed an amicus brief on the immigrant side in DeMoore against Kim, arguing that mandatory detention was unfair, it was inefficient, and it didn't serve legitimate law enforcement purposes. But even assuming, let's just assume, mandatory detention was a good idea at the time it was enacted, there's even less of an argument that we needed today. And I think that's so because the enforcement context is radically different. And I'll just list a few of the differences. First, as we all know, and Hiroka Kusuda pointed out, Congress has massively increased detention bed space. There were about 6,600 beds in 1995. Right now, there are about 3,400 beds. Second, ICE has finally begun to implement its risk assessment tool to guide its custody decisions, something that, as we heard earlier today, has long been in place in the criminal justice context, in the pretrial detention context, but it's been lacking in the immigration area. So in principle, ICE should be better equipped now to start making better decisions about custody. Third, as we heard Julie Myers-Woods talk about, we have ICE's Alternatives to Detention programs, and ICE have 2, and they're having striking success at ensuring appearance without resort to detention. Fourth, ICE has taken steps to address immigrants who don't show up for removal. You have the fugitive operations teams, which pose their own problems, but they exist now to go after people with outstanding orders. And also, deportation rates are up and overall migration rates are down. So these changes, among many others, make it far less necessary today to take this lock 'em up no matter what approach to immigration enforcement. So what can be done? As was alluded to earlier, there's renewed attention to the question of comprehensive immigration reform, and I think it remains to be seen how detention will figure in CIR. We at the ACLU and many others have long supported the repeal of mandatory detention, but that's highly unlikely, if not impossible, in this round of CIR, or at least that's what people are saying. And indeed, based on the last time CIR was debated, I think people are very concerned that comprehensive reform will bring forth even more draconian detention mandates as part of that grand bargain between legalization and increased enforcement measures. But that said, there are a number of steps the administration can take right now without any legislation to narrow its use of mandatory lockup. And I'm just going to run through them pretty quickly. Some of them are a little technical or legalistic. But all of these fixes basically involve the executive changing its interpretation of the statute as it goes about accomplishing Congress's goals of ensuring removal. The first we discussed earlier at the last session, although I've been talking about mandatory detention, everyone talks about mandatory 1996. To start, this concept of the aggravated felony, as many of you know, was a pretty narrow category, focused on pretty serious crimes like murder, weapons trafficking, whatnot. But in 1996, as part of the immigration reform, it was radically expanded to include certainly the serious offenses, but many offenses that are neither aggravated nor felonies. Certain theft offenses, filing a false tax return, things like that. Moreover, the aggravated felony ground was rendered retroactive, which means that a crime that wasn't an ag fel at the time you were convicted is now an ag fel. This is relevant to our discussion in this session because just as crimes trigger certain sentences under mandatory sentencing laws, being convicted of an aggravated felony will often guarantee your deportation. And this is because an aggravated felony will bar you from seeking relief from removal, in particular cancellation of removal, which is a long-standing form of relief where the immigration judge can permit you to stay in the country based on your equities and your family ties. So what the aggravated felony definition does is strip immigration judges of their discretion over removal while giving more power to the prosecuting attorney, who can now often guarantee someone's removal based on the charges. And as far as I can tell, the general practice among prosecuting attorneys is to charge the ad fel whenever it's available, regardless of whether there's a lesser ground of deportation that would still put the person in proceedings, but they have a chance to seek immigration relief. There's very little discretion in terms of the charging decisions, as far as I can tell. I don't have numbers, so this is anecdotal, but I think that's the perception out there. So this has extremely dire consequences for immigrant offenders. Beyond deportation itself, you become permanently inadmissible to the United States, and you face up to 20 years in prison if you re-enter the country illegally. So we're talking about rules that impose extremely severe penalties on people, essentially banishment, that are often hugely disproportionate to the underlying offense. And so, I'm glad Anil brought up the question of proportionality, because I think, we're long overdue for, a renewed attention to sort of the issue of like what proportionality has to say to deportation proceedings. Are there legal arguments? Are there legal arguments that would impose proportionality restrictions on deportations so that we can make sure the penalty actually fit the underlying offense? How does proportionality inform our policy discussions and legislative proposals as we move into the next round of CIR? And I'll refer you just briefly to recent scholarship by Mike Wishney at Yale Law School, who started writing and thinking about what proportionality has to say to deportation and what how it ratifies in the immigration context. And with that, I will end.
Okay, great, thank you. So this is probably a result of growing up in Cleveland and rallying to root for teams that lose every year, but I am not going to yet give in on the idea that repealing mandatory detention or cutting back on some of these provisions might not be possible in comprehensive immigration reform. But I want to get at that question, not by posing a question to you, Michael, but to Representative Lopinto. And it's particularly interesting and maybe appropriate to have a conversation about mandatory minimums here in Louisiana, because the leading proponent at the federal level for some of the first mandatory minimum sentencing laws in the modern era was Congressman Hale Boggs, who represented the state for many years, and he successfully adopted for the adoption of mandatory minimums in the 1950s under federal law, which made no distinction between drug users and drug traffickers for purposes of sentencing. And from my perspective, the most interesting thing to note about this law was while it had some uptake for a while and had states following on, it was widely then regarded as a failure, because by the 60s, mandatory minimums were under severe attack and as overly severe, inflexible, interfering with judicial discretion, and then in 1970, Congress repealed them with a bipartisan coalition similar to what you've described. Of course, then by the 1980s, all of this had been forgotten. So we've kind of been here before, which raises the question, what's needed to make these kinds of initiatives durable? Building and I guess the prior question is, in building the coalitions you've built, what kinds of arguments have had real uptake in terms of either sequencing particular reforms, which ones are the ones that you can get broad consensus around? Are the arguments more about fiscal costs? Are they about other kinds of things? Because I think sort of getting and unpacking some of that will be really instructive as we think about immigration reform, because even if it's the worry that I would have is sort of, we do some of these things on the margins, we have big legalization, we leave in place the surrounding broader discourse and logic of immigration enforcement, and then, that leaves us vulnerable for, when we're, the panic, if there's a moral panic a few years later around immigration or around crime, we're vulnerable again. So that's sort of like a open-ended set of questions, but sort of let's, I guess, start by sequencing. So where have you found arguments resonating around which kinds of provisions and some concretely that you've been working on?
And it's important to recognize how we got here, or what do we do. Reality of it is legislation is about emotion. You've got a committee of 15 of us sitting on the committee, and you have a sentencing guideline for a judge. Well, it's a burglary charge, it's a 0 to 12 years, and problem is someone in their district had a burglary that they thought that person should have went to jail for several years, and the judge ended up giving that person probation for whatever reason, whether it was a good sentence, whether it was a bad sentence or not. So that legislator, who doesn't know anything about the system, doesn't understand the whole process at all, I'm going to put a bill in because I think he should have got at least 5 years in jail. Which maybe that particular person should have got 5 years in jail, but the judge didn't do it. I don't know the facts in that particular case. They come in front of the committee, and detail their case out and how brutal it was and how they felt violated and everything else that happened. And bottom line is, they got enough votes. It's about counting votes at the end of the day. So, you know, you have enough to make it pass. So now we have a mandatory minimum of 5 years, which we don't on that particular charge, but that's how it grows, and that mandatory minimum starts. So you either have mandatory minimums with the most heinous type of crimes, or you have them because of multiple offenders. And the problem that I have, especially with our multiple offender statute, doesn't take anything to account. How many people in here are doing jail time for a first offense drug charge? The answer is very few. We don't have a lot in Louisiana that doing first offense drug charges doesn't doing jail time, unless they get revoked on, you know, on their probation, but most of them not doing jail. There's not very many on second offense. So they got probation the first time, inactive probation, take a few drug tests. Next time they got active probation, they passed that. So now it's their third offense, they're back into the system. They've got no treatment, have never been behind the jail, but okay, you know what, you're a third offender, we're sick of dealing with you. Here's life in prison, or we're going to triple bill you, and here's 40 years. So the first time that they ever end up in the penal system, they're there for 40 years, or there for life, or whatever that sentence ended up being. So we don't have the ability. Now it's okay, we can, you know, try to get them some education, but what education they're getting? They're not getting out of jail at that point in time. We needed to get the education in the front end, and that's part of the drug courts that you're dealing with, you know, to try to determine that. So it's recognizing that that's how you get to the mandatory minimums that are in existence today. The important thing that we've had over the last at least 5 years is having the right people on the committees to stop that. We've really done a very good job, in my opinion, over these last 5 years of having the right people on our, I'm not even going to talk good about the Senate, but at least on the House side. We've done a very good job. The senators will come over with bills that are trying to increase mandatory minimums on it, and we've said no, tough luck. We're not going that route, and we've killed them. So there's very few new mandatory minimums that we have enacted over the last few years. And the ones that we have, I mean, obviously they probably were they were no-brainers, at least from everybody on our panel from that standpoint. So it's one, stopping that tide to get back to that position. You know, now it's which way can you push forward in the opposite direction, and those will come in waves, and we're at that wave now. Part of it's because of fiscal needs. I mean, I use that as much as I can. Whether you believe in it for that reason or not, that's a reason to believe in it. I mean, the fiscal cost at the end of the day cost us a ton of money through the state of Louisiana, and unlike the federal government, we have to balance a budget at the end of the day. So if you don't want to let prisoners out of jail, you know, from that standpoint, well, then you've got to cut education. If you don't want to cut education, well, you've got to cut healthcare. And those are the three places that we have in the state that have the ability to have funds cut. So if we can do some smart things to alleviate some of the budget needed by Department of Corrections, that money can transfer over to those other places. And you've got a lot of people that realize it's not the end of the world. And we've made those changes, and we're going to continue to make those changes. And you know, you're going to have bad people. But one of the facts, you know, we have a recidivism rate here in Louisiana around 50%. But people that are released on parole, it's less than 10%. Problem is, we don't allow anybody to get to parole, because if you are a violent offender, you got to serve 85% of your time before you're eligible. Well, then you end up getting good timed out before you're even eligible for parole. So there's no incentive for that person to get into jail, to obtain the GED, to do anything, any of the programs that we know can show that it lessens the recidivism rate for those people, because they have to serve their 5 time, or they have to serve their full time. Where if they get paroled out, now we have at least a thumb over them to make sure that they're doing the right things, make sure they have a job. So we've got some programs in place that are working very well, but it's not affecting anywhere near the amount of people that we have within our system to do it. And truly, I mean, you got 40,000 people. I can show you some programs that are affecting 1,000 of them very, very well. Problem is, there's still 39,000 out there that aren't getting that treatment.
Michael, did you have any thoughts about sort of the political dynamic to push back?
With respect to mandatory detention?
Yeah. Detention, yeah, or the aggravated felony, the sweep of the aggravated
Yeah,
felony
I mean,
definitions.
I guess I agree with you. I wouldn't want to sort of declare that it's that repeal is impossible, or that sort of meaningful changes to the immigration enforcement laws aren't possible. I think we're not in the tough on crime 90s. The political context is really different. And the renewed attention to CIR is about that. I guess where I'm coming from, and I don't live in DC, and I don't really do this work, and so I would certainly encourage people who are from DC or doing this work on a daily basis to please add their voices, because I feel like I don't have a lot of expertise or a good view as to what's actually happening in the Beltway. But I think there's a sense among many people that there's going to be horse trading. Well, the last time CIR came up were much more draconian enforcement measures. I think the groups are in a different place. I think that they hopefully they'll be less willing to do that, to make those trades. I also think it's telling that, for example, Lamar Smith's detention bill, which I don't know if many of you were probably following, which would have created much more draconian detention mandates than we have now, like indefinite mandatory detention for evil and proceedings, that kind of stuff. Expanding the rolling back on civitas, provisions like that, the detention of asylum seekers, really terrible stuff in that bill. And in fact, Representative Smith was able to identify a bunch of really bad cases that stood to make that law. I don't even want to talk about the cases that they were able to identify because they were quite gruesome. But, as far as we can tell, the bill didn't really have traction, and the Speaker Boehner didn't really push it. And so, I think that experience also says something about the extent to which Congress has a taste for more detention. But honestly, I don't know. I really encourage other people who have a much clearer sense of what's actually happening in Washington.
Well, one interesting thing, I also have questions about this, but one interesting thing as an outside the Beltway observer to the discussion over that bill was a counterpoint to this observation, Representative Lopinto, that you've made about fiscal considerations being something real for a lot of people, in that very explicitly, as I recall that hearing, Congressman Smith said that, cost shouldn't be a consideration. And of course, the constraints upon the federal government, as you noted, are not operating in the same way as states that have to balance their budgets. And the political economy of where money flows for detention also is different. So to the extent that states and localities are in fact tempering incarceration, does that create excess space then that they can get cash flow from federal government? That sort of creates that the political economy is a little different.
Just to pick up on that, I think that's a really, really good point, and that's why I think there needs to be work in terms of just like sort of thinking about an integrated strategy. There needs to be work lobbying the state and local governments, explaining why immigration detention is a bum deal economically. And we've started working with folks to develop research about how much like in the criminal justice context, more detention beds doesn't actually help grow local economies. It doesn't really lead to job creation and that kind of stuff. Of course, people stand to benefit there, and there's a price tag on each immigration detainee, and that's revenue, And so I think it's complicated, but it is necessary, because I do think that is one of the primary engines of detention, the growth of immigration detention. So.
Okay, so we've got about 15 minutes, so why don't we open this up for questions and comments and dialogue.
Professor.
Bill Quigley from Loyola here. I just wondered how you counter the forces that want to increase incarceration. I was in Georgia last week. They have a Stewart detention facility. I think it's 1,800 beds in this private facility that is in a county of 6,000 people. This is they're not good jobs, but they're the only jobs other than agriculture in that area. And obviously those folks and the people that benefit from them are pushing for more and more incarceration. I was just wondering, we have some private prisons and we have the sheriffs of Louisiana who have an investment in this. How do you address the trying to bring down the number of people in prison when you have people on the other side really pushing from an economics point of view?
You know, it's not, we have enough prisoners to go around. Okay, so that hadn't really been the issue as much as, I mean, part of Louisiana's problem, and I'll say, we also have a higher offender rate here in Louisiana, which contributes to a higher incarceration rate. I'm not to the standpoint to say, okay, we're going to be New Hampshire at the end of the day. Louisiana is not going to be New Hampshire today. Now, we are officially high, yes, but we're not as high. We're going to be higher than other states going forward. I mean, that's police are reactionary. You know, the bottom line is, from a police standpoint, and me being that one, police aren't necessarily going out there just to make arrests. You know, I mean, obviously you have some proactive units, being narcotics and those type of things, but the rest of it, they're reactionary. I mean, they're not putting you in jail or knocking on your door saying, I think you committed this burglary last week, unless, I mean, that's the thing that they're dealing with. So they're reacting to crime. But when it comes down to the actual laws that are being affected or the amount of sentencing it comes down to the legislators are there. And truthfully, that can change in an administration depending on who's on those committees. Again, it's been very, very easy to vote to, okay, yeah, I'll increase that. I mean, nobody's going to get hurt back home in order to do it. But if you don't have it on the committee level in order to stop those bills to going forward beforehand, it's very difficult to kill them on the floor in order to go forward. So that's the issue that you've got to have the right committee in place. And I'll give credit to not only the governor, but Chuck Leckley, who's the Speaker of the House, who appointed me. When that happened, they came to me and said, okay, Joe, these are the people that want to be on criminal justice. What do we want the makeup of that committee to be? And I had a good hand in that, to be able to say, this, you know, we've got both sides of the equation. Don't want it to be, you know, completely to one side, but I want people that are reasonable, that understand the issues, that understand when you come forward, they're not going to get the emotion built up in them. They understand the big picture and can say, no, we're not going to go along with this. And we tell a lot of people no. I mean, that's the reality. We tell a lot of people no. We're going to give the judges the discretion in order to make a decision on that particular individual and what's best. Now, the problem that I also say here in Louisiana is many of the judges aren't as informed as I'd like them to be. So they don't necessarily, you know, get. We had a tour with the Sentencing Commission in which we had about 30 judges that were up there for their conference the day before. And out of those 30 judges, I think 5 of them had previously been there. So the 25, I mean, and so think of that percentage for all the people that didn't show up. We're only talking about the 30 that went. But getting them to that position to understand the ramifications of the sentences going forward is extreme, you know, and it's getting them to be there to say, all right, look, no, this isn't, you know, instead of me giving you 80 years in jail or 99 for that armed robbery, I'm going to give you 99 for the armed robbery, but I'm going to make you eligible for parole after 40. Let's make them eligible for parole after 40. Doesn't mean they get out, but it means they have to go prove themselves to that parole board that there's no longer a threat and it's the right thing to do at that point in time. And it's trying to convince them to add that extra sentence in there. Add that extra sentence of parole eligibility after a certain amount of years instead of just knocking down that 99-year sentence. And that's what you're trying to educate them on a daily basis in order to make it happen.
Yeah.
So I hear all the time from jailers throughout the state that hold immigration detainees as well as correctional detainees, that they always say, oh, we love the feds because they pay more money per head. So, and it's a business to them, basically. And it brings business to the community, employment to the community. Multiple communities are depressed. And now in Louisiana has this big private prison operators in place. They are here to stay. There are forces to deal with. And I'm pretty sure they will be bringing lobbies to the legislature to lobby for expansion of immigration jails, because I understand that statistically showing the correctional population is decreasing nationwide. How are you going to fill the empty jails? Immigrant detainees. So I think it's coming to you to deal with that issue, and I hope you have a guts to say no.
Well, you gotta remember, I'm your state representative. So that immigration issue, other than Arizona, stays in Washington, you know?
Okay.
So I don't deal with that. In fact, they asked me to speak on immigration reform. I said, I don't know anything about immigration reform yet today. I can tell you about mandatory minimums, but that is not my topic. But that is a reality. I mean, we deal with that on the local level. As I said, 20,000 of our incarcerated inmates are at local jails, making a per diem rate.
Right.
And many of those smaller parishes around the state, they rely on those funds in order for the departments to happen. And don't get me wrong, they are great partners. But we need to make the determination that, look, we want lesser offenders, and I'll pay you a higher per diem rate. I don't necessarily, I'm not here to cut the budget for, I'll pay you a higher per diem rate if we can have less offenders that are recidivant. And the problem is that they're going in, they get no treatment at many of these local facilities. Some of them are actually pretty good models, but most are not. And trying to give them the incentive that if they do this in order to help the people not come back, we'll pay you a higher per diem rate. But we've got to get to that point. And the problem is there's just not enough money to get to that point right now. And so.
So I just want to refer people, so Greg Hooks, who's a sociologist at Washington State University, has done some very interesting empirical research about how prison construction doesn't actually help local economies because it doesn't lead to job creation. Who knows how persuasive these numbers are in these policy debates, and I do think, for example, they might have better strategic use when you're opposing the opening of new facilities or, those kinds of site buys as opposed to, facilities that already exist and local economies that have become dependent on those facilities. But it's still worth checking out, and if people want to, if they give me their information, I can send the studies to them.
So before you ask your question, we've got about 8 minutes, and I saw a couple other hands. So maybe we'll take these 3 questions in a row, and then you can respond to sort of as you choose to all of them. So we'll take you, and then Lindsay, and then this question in the middle.
I'm so glad to hear there's a culture change that's coming here in Louisiana. I've got a bunch of questions, but I'm going to just ask this one. You said that you don't have anything to do with federal detention, and that's great. But there are legislators at the state level that have been trying to create crimes in Louisiana that would, try to take on federal authority and arrest immigrants for being here for, let's say, working without documents or what have you. And there has been some bills that have come up in the Criminal Justice Committee. Now that the presidential election is over, and we saw what happened in Alabama with their law, and Arizona with their state level immigration law. What do you think the appetite is now for Louisiana legislators in regards to trying to bring immigration enforcement bills at the state level?
Before you respond, I just want to get the other questions on the table.
I'd be curious to hear, I think a lot of in both contexts, that.
So it was very, very encouraging, to get to that point. All right, now we did all these questions on ALEC. I actually spoke at ALEC's convention when it was in New Orleans 2 years ago. We're obviously dealing with fiscal cost, and that's the purpose of ALEC's trying to get involved with it in order to make changes on to be smart in this situation. I mean, that's what we're dealing with on. Let's concentrate our funds on other portions of the budget. Let's not increase these mandatory minimums just arbitrarily. Give the judges the discretion that they should have. But just because we give the judge discretion, there's a second part to that, and it's educating the judges, on what a proper sentence should be or needs to be. So I mean, I don't think ALEC hasn't really been a huge player, I would say, in this. I mean, they've had some different type of legislation, but it hasn't been a huge deal.
Bringing the decision making, the perspective of adjudicators, right?
Yeah, I think thanks for that question, Lindsay. I think it's hugely important. I think lately I'm not aware of, at least in the immigration side, of that much outreach that's happened. Well, actually, no, there's some. So I think in some cases, there have been outreach to former INS officials to kind of act as messengers on the detention issues, but we could use a lot more of it, and I think IJs as well. I mean, my understanding, and for folks who actually worked on this campaign, immediately after 1996, there was a Fix 96 campaign, so an effort to repeal the more draconian aspects of the 96 laws. And my understanding is that there are a number of either former or even current INS and immigration judge spokespeople involved in that effort. I've also heard, anecdotally that many IJs who lived through the shift between the pre and post 96 found it personally devastating that they had their authority to kind of make decisions over whether, to decide, based on your equities, based on the fact that you have a family here, that you've worked here, that you're a good person, we're not going to banish you based on your past crimes. So I think it's essential in, both understanding what's happening and kind of advancing policy change.
And then what appetite for Arizona or Alabama type of laws?
And we've had laws that have come through, and obviously they haven't gone anywhere here in Louisiana. And I think with some of the decisions that have been made, I don't foresee it, because once you educate them, it's like, what are you getting? I mean, and they don't understand. Oh, it sounds good. It's a 30-second headline. It sounds very good. But when you walk them through that, this is what. Okay, we created a misdemeanor for not having an ID that we're going to put somebody in jail for 6 months. Congratulations, now you're paying for it. You still haven't deported them. When they realize that even if their issue is I want to deport every illegal immigrant, you haven't done that. So you're contributing to a problem that you're not fixing. And most people, it's having the right people to be able to go up to that microphone and say, look, I can be against illegal immigration all day long. I can say I want to deport every person, but this isn't the fix. If that's what your fix is, run for Congress. But here on the state level, that's a mistake or a problem that we don't want. I don't have enough room for the actual criminals, much less somebody that doesn't have their ID. I'm sorry. Whether they're illegal or not, it doesn't really make a difference to me. So there really hasn't been a huge push. That even though people have filed those bills, even that hasn't really been our debates over the last 5 years that we've had to really fight. They've come up, there hasn't been a whole lot on the other side. Get over it, see you later, and we move on to the next bill. So, and we deal with, criminal justice is, we run them in and run them out. I had 160 House bills alone, and I think another 100 Senate bills come through Criminal Justice Committee last year. Put that in perspective, our Agriculture Committee had 12. So I don't have time to fool around on bills, and our committee knows that. We'll go through 30 bills a day. So you better be ready, you better sit down, do what you got to do, but we know where we're voting, it's over with, let's move on to the next one. So I don't pay attention. I'd say I've got the easiest job in the world. I got a red and a green button. I'm just going to figure out which one I want to press, but it's really easy. Make a decision, move on to the next one, and go forward.
All right, well, we have to wrap up with that. Thanks to both of you. This was a really terrific conversation. And on our revised schedule, we will have 30 minutes for lunch, so back here at 1:20. Right, and we'll be back on schedule. Sorry.